Very good evening, Raj.
Yeah, good evening, sir. So, welcome to another episode of Tech podcast. So, today we are going to speak about navigating intellectual property rights for startups.
Hmm.
So, again, we had a long weekend, sir. So, as we jump into this insightful series, um, please let us know about understanding IPR and their significance for the upcoming inventors or creators. So I'm excited for today's live session. Let's see if anybody would hop in. Um, so I just wanted to hear from you. How was your weekend, sir?
It was great actually. Had many plans, but had time with family, not and postponed the outside works as well. It was
Oh,
good.
okay, so let's hear the practical solutions for overcoming these IP challenges. Or how is IP due diligence important in evaluating startups or startup successes and securing funding and so many things which need to be covered today. So let's hit it. So, what are intellectual property rights, sir?
Intellectual property rights, shortly called IPRs, including patents, trademarks, designs, copyrights, and a few other, are rights granted by the government to inventors. So government means wherever it is filed. Example, if it is filed in India, Government of India, and under Government of India, Department of Industrial Policy and Promotion. Under the department, we have Indian Patent Office in Chennai, the main office, and we have branch offices in Mumbai, Delhi, and Kolkata, and we have a training wing in Nagpur. So all of these offices are part of the department under Department of Industrial Policy and Promotion.
Okay.
So if an IPR filed by any person, any company, it can be a Indian national, individual Indian national or Indian registered company, or a subsidiary of a foreign company in India, or a foreign company itself from outside. So
Okay.
anyone who files an application for grant, application for registration. Patent we call the registration as grant, but trademarks we call it as registration, designs we call it as registration, and copyright we call it as registration. These four, based on the subject matter, based on the type of invention, based on the type of work, uh, these are divided: patents, trademarks, designs, and copyrights.
Okay.
So it's a grant by the government to inventors and creators for their inventions and creative works under
Okay.
laws such as Indian Patent Act as well for patents, and as per Indian Trademarks Act 1956 as per trademarks,
Okay.
and as well copyrights and designs. So these rights allow the owner to exclude others from making, using, selling, or distributing the patented invention or the trademark, if it is a trademark, that the brand name, without the owner's permission or the applicant's permission. IPR is crucially for fostering innovation as it provides inventors with the recognition and financial benefit necessary to continue their creative endeavors.
Okay. So that's terrific, sir. As in, are there any of our patentees or any other inventors in our circle uh, who had used their right to protect the patent laws or has been, did they protect their inventions? Any of our clients in general, like
Yeah,
anybody in the last decade, did they try to leverage the Patent Act?
you reminded me one question last week. One of our client, he's our well-wisher, and who actually, including you, like you are part of the newsletter group, and he's the one who sends the first message every morning at around 5 a.m. So he
Okay.
asked me this question, Srinivas, whether any of our group members uh, succeeded with their IP grants, they could actually commercialize, and any of them are like become superstars or maybe become rich with the IP assets. So this is the
Okay.
question he asked me last week, couple of days on Friday, I guess.
Okay.
Yes, like we have successful startups for whom we worked in last 1 decade, in last 10 years. So we started in 2012, and from then we filed more than 1,500 patent applications, 15,000 trademark applications, and etc. Copyrights, designs, and more other jobs related to other forms of IPR.
Mm-hmm.
So one good example, Skyroot Aerospace. We all know, like the Hyderabad-based startup.
Oh,
So
deal.
we are supporting them. Yes. So and there is one startup, Hyderabad Innovations Private Limited, which actually is coming up with a tri. Uh, uh, it's not a tricycle actually. It's a three-wheeled automobile. I mean, three-wheeled motorcycle.
Yeah.
So they got a patent grant last month, and we have. I mean, it's one of the grant, but they had multiple design registrations, and there are many, like there are pharma companies who got patents and got their inventions commercialized. So how can startups identify their IP assets, or maybe why IP are crucial for startups? If you ask me, IPRs protect the core innovations and creative works of startups, giving them a legal monopoly over their use. This protection is crucial for maintaining a competitive edge, attracting investment, and enabling startups. Mind you, attracting investment, Skyroot attracted more than 400 crores of investment
Oh, God.
in last 2 years.
That's great.
And IPs enable startups to grow without the risk of their innovations being exploited by competitors. So this is the
Okay.
main thing. And under the Indian Patent Act, Section 48, Section 48 provides this exclusivity to patent holders, which is vital for startups to safeguard their inventions.
Wow. So how can these startups identify their IP assets, sir?
Startups can begin by conducting an internal audit. So this not only startups, this is common for all. But
Okay.
startups, why startups very much they have to conduct an internal audit. If you ask me the frequency every month, I say startups can begin by conducting an internal audit every month for all their innovations.
Okay.
It can be their first product they thought of, and its design and its brand name, including their startup's name, and other creative works like their posters, or maybe a pitch deck which they are actually pitching before an investor. All these things, like they have to conduct an internal audits to see whether they can create a value out of them or create an IP out of them.
Okay.
So also they have to consult, or they need to have a patent agent, or maybe an IP expert on board, or maybe as a consultant. So consulting with an IP professional can help in identifying which aspects of their business can be protected under different categories of IP, such as patents for inventions,
Okay.
trademarks for their brand identity, copyrights for original works, or copyrights for their software part, and trade secrets for their maybe for their costing, or the marketing material, all those things.
Okay. Which is again, sometimes I wonder, sir, like Tech Mahindra, there are lots of companies with the word tech. So the brand identity protection, which you just mentioned, trademarks for brand identity. I
Hmm.
wonder what are the, I mean, what do companies do when their part of the brand is used by some other brand? Like, for instance, Tech Mahindra is one example, but I know lots of other companies who use the word tech. Like even we are Eva Tech, but Tech Mahindra, Eva Tech, and there is also Moria Tech. Moritech is another company where my brother-in-law works. So I wonder, is it okay to protect the brand by using the word tech for splitting the names, or does it fall under brand identity violation under trademarks?
We will. We have a separate episode planned for this, but it's a relevant question even now. So for startups, I mean, this comes under the same the previous answer of mine for the question how an strong IP strategy can be built by startups, or maybe startups can identify their IP assets.
Okay.
So during their audit, it is something very crucial. And they did an audit, for example, and they identified their brand name is very unique, or maybe whatever they thought, like Tech Maurya, Tech Mahindra, or Tech Eva. They thought of something which starts or ends with Tech.
Yeah.
Example. So and some other people, tech is a word anyone can use. So Maurya or Mahindra are different here, and Eva is different here. And Eva with the prefix Eva Tech, and Mahindra with the suffix Mahindra Tech,
Okay.
or Tech Mahindra with as a prefix. But tech can be used, but the other word, the core brand name should be different, like Mahindra or Eva in this case. And one example I can give in this case is like what are the consequences of not monitoring the competitive IP landscape, or maybe to that effect, I have to. And I have an example of Airbnb. So their initial name is different, and they actually renamed their brand after some traction.
Oh,
Then they had to actually face this challenge to have that name Airbnb.
oh,
Um,
Air Bed and Breakfast was the origin.
yes,
Okay.
yes.
I was just
So
Googling. Okay.
like that, like brand selection is very much important.
Oh
So
God.
it should be
I,
unique. It
I
should
didn't
be unique.
know. I didn't know B&B means bed and breakfast. I mean, that's a short form of B&B, bed and breakfast. Airbnb. Okay.
It's B2B also.
Oh,
So
okay.
business to business. That means like I can offer my property on Airbnb, and then it can be taken by another business also for their maybe office use, or maybe for their um, recreational purpose, or whatever, for their guest house or something. So it is B2B connection, and it's also bread and butter. But it's not very relevant with bread and butter. They thought, and they thought of actually revamping the brand.
Okay.
So brand selection is very important. There are multiple restrictions on selection of brands. For example, Bharat cannot be part of Bharat Petroleum. So it is okay for a PSU or a government institution or a government funded organization.
Mm-hmm.
Indian Oil, again, it's also okay. But as a private party, a private person, or a private enterprise, we cannot actually coin our brand name with India or Bharat. So there is a restriction under different other acts, like we have a flag act, so which says like we cannot. In, everyone can, or maybe for commercial use, no one can actually use the colors of the flag or the Ashok Chakra.
Oh,
They cannot have flag colors in a logo of a commercial purpose used brand name.
okay.
So we cannot use the word Charnar. We cannot use Misa, your last name, my last name Madhipati, because like it's not you and me with our last name, and we have other people sharing the same last name. So we cannot have that word as a brand.
But
So
how
there are
come
restrictions like,
how come Narayana Group School has his name, sir? Narayana is a
yeah,
good
that's
name.
what trademark registration. I mean, we are talking about a good brand, good business, good idea, so that like you protect it, and it can be valued better when compared with others.
Okay.
So we are, I mean, Trademark Act is not saying like you cannot do business and we will stop, we will come and stop you if you use Narayana or maybe Madhipati. They won't. They are, Trademark Act is not saying that. Trademark Act is saying like it cannot grant registration for generic things or which are very descriptive or which are restricted words.
Okay.
Sri, Om, Namo, Venkateswara, Srinivasa,
Yeah, Rao's Technical School
Balaji,
and all. Yeah.
Lakshmi, Mahalakshmi.
So generic
All these
words.
things are things like either
Common.
God's names or places names or maybe surnames of people or places names. So
Okay.
all avoiding all these things, like we need to create a brand.
Okay.
So best examples like the one condition is like they should not be under restrictive category, and the other condition is like they should not be descriptive. For example, make my trip, book my show.
Okay.
They have registrations. Still, they have registrations, but they are not good trademarks as per the Trademark Act.
Oh, because
They
it.
are not very good trademarks as per Trademark Act because they are describing. I mean, the word "make my trip" is describing what you can get there.
Yeah.
Book my show. It is very descriptive, highly descriptive to their services.
Yeah.
Still,
And also
still we will get registrations for the logos, not for the names. If
same
you see
thing.
their registration certificates,
Yeah.
it will be clearly written. The order of the acceptance will be clearly having that it is a conditional acceptance, not for the word, only for the logo.
Okay. The same thing with tea time, but as we are running short of time, so what types of IP protection are available for startups, sir?
Like others, all the forms of IP, it's all that they have to identify what they have and within what they have, like when based on the category or based on the eligibility, they can have patents for their inventions, for their products, physical devices, or also softwares, and trademarks for their brand name and copyrights for their maybe artistic or literature work, and other forms like trade secrets. If they have any business material or marketing material, they can keep it as a secret, and they are called trade secrets. All the forms of IP based on the field of the study of the startup. If it is into agriculture or if it is into pharmaceuticals, the forms may differ. Apart from trademark, apart from copyright, the type of patents may differ if they are actually working into plant varieties or something. So there is a separate act within Patents Act. There is a separate act for plant varieties.
Okay, now I wonder, apart from the startups, IP protection now, I wonder what kind of protection, IP protection are available for movie names like Pushpa 2 or like probably any other movie name like Bahubali. So how do they protect their brand names? Like, does that come under copyright only, or does it go under trademark?
Any name, even Bahubali or maybe any movie name, it is for commercial exploitation, right? So it is not a product, but it's a service, or you can call it as service only. It comes under Class 41 entertainment services. So it can be a production house like um, uh, Ramanadu Studios or maybe any other production house. So their service, they build movies, and with the title of the movie, they release. So the production house name will also go under trademark registration. The movie name will also go under trademark registration, the names, but the script or the video recorded or video, I mean, which is made as a movie, will go under Copyright Act.
So on average,
Will get a copyright registration.
okay, that's great, sir. Thank you.
But very few movies apart from the bigger ventures like the Pushpa 2 or maybe Bahubali 2. So they only file trademarks for the name, citing like immediate misuse in other categories of products.
Okay.
Example, after Bahubali, there are many companies into cement, steel, and tools and machinery. They all came up with product names Bahubali
Yeah.
because it is suiting their product. It is very
Yeah.
much suiting their product. After the movie, it's a big hit. I
Yeah.
mean, if they name their cement bag product with name Bahubali 2.0 or maybe Bahubali Bahubali, so it's a hit for them. Like it's a easy move in the market.
Yeah, that's
So
right.
for that
Even
reason, even Arca Movies, Arca Media, which
yeah.
is of the director's company, they filed a trademark after the release of Bahubali Part One
Oh God.
in multiple categories. Not only in their category, they also filed in Class 6, Class 21, whatever the classes I am telling, the hardware class and the cement class or the plastics class. These classes also they filed across 15 classes out of 45 classes. They filed in 15, 16 classes trademarks, and they initiated legal action also of misusing I mean, the style of writing as well. Writing
Okay.
Bahubali is one infringement across the classes. Using the same font style that Bahubali has
Okay. That's
in English,
actually
English or Telugu, like you see that kind
fun.
of writing style they have,
Yeah.
particularly. So even people tried copying it or using it.
Yeah. So for
So for
each
that
movie,
reason, they filed trademarks.
okay. So
Not everyone files.
okay, for each movie there will be like dozens of IPR filings are like copyright, trademark, and obviously I
Hmm.
don't think patent can be done.
We have like in our kitty, like we file for a couple of directors, like famous directors. I cannot name them.
Okay.
Our clients, their companies, and even upcoming movies, like we file trademarks and got registrations. But the movies are yet to release, so I cannot disclose the names as well right now.
Yeah, yeah. But again, so each film gets an average of 12 or dozens of copyright filings or
IPs, but they are not very much serious because like they don't. They also have another way of protecting their scripts. They have an movie producers association and directors association. There is a movie association, right? So
yeah.
they have a registry. This is already known. Copyright Act doesn't mandate registration under Copyright Act only. Anyone as an association who can actually take applications from members and maintain a registry saying like this name is proposed by so and so person or company, a production house on this date, and we are writing into the registry and giving him an acknowledgement. That is a proof.
Okay.
So like that, these movie names are protected actually.
Okay.
So as they have this system already existing from quite some time, from Telugu movie industry or maybe Tamil movie industry starting from Madras days.
Oh,
So they have this thing. The movie association will maintain a registry of names,
okay.
and whoever registers, like they will have that right. For that reason, they won't come for trademark registration. But some people, like if they see a monetary benefit in terms of selling toys or maybe some other goods with that name after the release of the after success of the movie. So
Okay.
citing this benefit, like some directors will file for trademark registrations.
Okay. This is terrific. As in for anybody who is into becoming a writer for movie scripts or anything else in entertainment, I guess this will.
Upcoming writers will come to us, like
Okay.
will come to IP lawyers, and they file copyrights
Okay.
because like they don't have a footprint yet, and they cannot actually go to the movie makers association and take a membership because it costs something. So rather actually spending on first getting a membership and then going for a registration in their registry. So it costs around 45,000 rupees for the
Okay.
membership on the registration in registration in their registry. Rather they come to us, or maybe some people try on their own and file a copyright application under Copyright Act, Indian Copyright Act.
Okay.
So the upcoming people.
Okay. So that's great information, sir. So this would be the last one, in the interest of time. Again, how does a startup benefit from having a strong IP strategy?
A strong IP strategy is required for everyone. Any company who is willing to or wishing to drive on IPs or ride on IPs, rather I say, a strong IP strategy ensures that all potential IP assets are identified, protected, and utilized to their fullest potential. Especially for startups, this can lead to increased competitiveness, higher valuation, and more attractive prospects for investment. So this is
Okay.
very important for them. So IPs are valued in multiple ways. So
Okay.
the cost-based calculation and the market-based calculation, which actually are prominent. So
Okay.
initially, any for a startup, cost-based calculation would give a lesser value, because cost-based valuation means whatever the cost incurred for the development of the technology.
Okay.
So it will be very less for a startup, or for instance, for anyone, for a small entity or maybe a startup, it will be very less, because like they will use less resources, and actually they use more of their mental resource to to develop a prototype, or maybe to develop a first minimum viable product.
Okay.
So cost-based calculation will be undervalued, or
Okay.
cost-based valuation will give less value for their IP. So they have to concentrate, or maybe they have to see the prospect of valuing based on the market size or market captivity it can gain in next 5 years. So
Okay.
for doing any of the valuation, it can be cost or maybe market-based valuation. So first they need to have IP. So first they have to file IP, and they have to see they'll get an IP registration, so that like these IP assets can be valued, and this valuation can attract the prospective investment they are actually looking at.
Okay. And I guess that helps them with the funding or the initial funding to
Yes, obviously.
higher
Yes,
valuation, which
obviously.
you mentioned.
Yes.
So again, as we end today's talk, sir, so could you also brief about the Section 11 instance? Like, what does Section 11 speak about in terms of having the strong IP strategy for startups?
Yes. So as we are talking about startups, and we cannot expect a patent grant in case of patent. Trademarks can be uh, registered in 9 to 10 months, and designs can be registered in 6 to 8 months. But patents will take a bit of time. Normally it is 2.5 years, 2 to 2.5 years. But even with an early examination given for startups, it can last up to 12 to 18 months.
Okay.
Even 12 to 18 months, a startup to sustain is a big challenge. Or maybe the founders, I mean, pushing it to 12 to 18 months till a patent grant happens, and then valuation, and go to an investor for a validation stage or whatever. So it is a bit tricky, or maybe it is tough. So a, a publication, filing an application, and getting it published early under Section 11 of
Okay.
Patent Act, and whatever the result in the examination, or the time it takes for a grant. So
Okay.
this is a critical step in the strategy to secure and leverage IP rights. That means from the date of publication only, anyone can actually access the IP, even a court. For
Oh,
example, after grant, they can go to a court seeking injunctive reliefs for an infringement.
okay.
But court calculates damages from the date of publication. So date of publication is very critical to show to their investors at the first point, if it is not yet granted, or to claim on someone who is actually infringing or maybe copying their product at a later stage after grant. So both the critical thing is like their patent publication date. So for that reason, apart from the valuation game and having multiple IPs, so their applications need to be published so that like they help them in pitching to a customer, probable customer or maybe an investor, or in a case of infringement, they can actually get a relief from the date of publication or damages calculated from the date of publication of their patent.
Okay, this is awesome, sir. Thank you so much for this wonderful insights. Probably we'll continue with the rest of it for the intellectual property rights for startups in another
Yep.
episode. And where can everybody find us? Like, if somebody would listen to the replay or will catch this on Apple Podcast or Google Podcast, or probably listening to this on YouTube Podcast. If they're
Yeah.
listening to this, what is the best way to reach you?
Best way to reach us, we are always available on these platforms as well. Otherwise, like they can Google Evatech or maybe Evatech obviously. So it's on. They can email us at info@evatech.com,
Okay.
eevatech.com, or the mobile or maybe the landline numbers that we are publishing on the pages. So, or an inquiry form or an appointment form on our website, evatech.com.
Okay. Awesome, sir. Thank you so much. And we will catch up with everybody on another episode of this intellectual property rights for startups. Thank you so much for your time, sir.
Thank you. Thank you very much.
Have a
We're
great
signing
day.
it off. So